and thank you so much for joining in today. This episode is being brought to you by Summit Safety. They have asked us to partner with them in presenting some information regarding the new emergency paid sick leave and the Emergency Family Medical Leave Act that is set to take place on Wednesday, April 1st. So many of you are aware that there is a new law that is set to take place or go into effect tomorrow, as a matter of fact, which is April 1st. And it's in reference to the emergency paid sick leave and the expanded family medical leave. So who is considered eligible? An employee of a private sector employer with fewer than 500 employees and certain public sector employers. There is no length of employment required under the Emergency Paid Sick Leave Act. So what benefits would be presented or an employee might be eligible for? There is a benefit of full pay up to $511 daily. For those employees who meet that criteria or eligibility, the employee may receive up to 2 weeks or 80 hours of full paid sick leave for a COVID-19 related reason. For full-time employees, up to 2 weeks again, 80 hours, or even a part-time employee based on the average of hours worked over 2 weeks. This is paid before using the company instituted PTO. Okay, so under the emergency paid sick leave, there are several eligible situations to qualify under that full pay, as we talked about earlier, for both full-time and part-time employees of the 80 hours, or a max of 511 a day. So such situations where eligibility may take place would be when an employee is subjected to a federal, state, or local quarantine, or even an isolation order under or related to the COVID-19. Another eligibility situation may be where an employee has been advised by a healthcare provider to self-quarantine, again, related to the COVID-19. Finally, if an employee is seeking or experiencing the COVID-19 symptoms and now they're seeking a medical diagnosis from a healthcare provider, they may also be eligible for this full pay for 2 weeks. Under the, again, Emergency Paid Sick Leave Act, in eligible situations where the employee may not be entitled to full pay up to $511 a day, but where they may receive their pay at 2/3 their normal compensation. The eligibility criteria for that is when an employee is caring for an individual subjected to a quarantine, isolation order, who has been advised by a healthcare provider to self-quarantine. Where an employee who may be receiving 2/3 his or her compensation, the criteria may be where an employee is caring for a child whose school or daycare or even their child care provider is closed, no longer available, and it's all related to the COVID-19. Now again, this would be a minor child, someone who is under 18 years of age that the employee is caring for. Another situation where an employee might be eligible for their 2/3 compensation under the emergency paid sick leave may be if an employee is experiencing any substantially similar conditions specified under the HHS. Okay, so now we have completed an overview of the emergency paid sick leave. Now we're going to dive into the expanded family medical leave. So it is a little bit less complicated, whereas the only criteria or qualification for an employee under the expanded family medical leave would be should he or she have their school, child's school who's under 18, be closed due to COVID-19 reasons, or even their normal child care provider that they use. So when that is no longer available to them and they have to show that supporting documentation, whether it be from a school official, an email, newspaper clipping, clipping, website, things of that sort. That would be certain documentation that the employer may be able to accept from the employee. And that again, the differencing of criteria of eligibility is not only does it have to be COVID-19 related for school closing, childcare closing, or the childcare provider is no longer available for a minor under 18, but the employee has to have worked for the employer for at least 30 calendar days. We oftentimes recommend that there be a checklist, and so for this it'd be really good. There's nothing issued yet by the Department of Labor as far as forms or requests or anything like that, so we're trying to kind of operate a little bit by being organized and maybe having a checklist. And with that, we often look at, is the employer less than 500 employees? Has the employee been employed for 30 days? Does the employer show that they have a COVID-19 school closing, childcare facility closing, or their provider is no longer available due to COVID-19? Then the employer may be saying that this employee obviously is meeting the criteria and is to offer the expanded family medical leave. So as we continue on with the expanded family medical leave and criteria and who's eligible, the biggest caveat in this is not only is it due to a school closure, child care facility no longer in operation due to the COVID-19, or the child care provider is just no longer available, is that an employee is not able to work remotely or through telework, or maybe it's the employer's not able to extend that offer. Certain scenarios may be in manufacturing where an employee's job is to work on a manufacturing line, doing welding, or maybe it's a receptionist who needs to typically take incoming calls and greet visitors, and they're not able to work remotely. Then they may be considered qualified under this expanded family medical leave. We've had several employers say, okay, all of a sudden we have this expanded family medical leave that's to take effect April 1st, and they're calling it sunset, but basically it's conclude the end of this year, December 31st, as long as the COVID-19 has ceased, where we're getting these smaller employers saying, you know what, we weren't even under family medical leave when we were less than 50 employees, and now we're being asked or required under this new expanded family medical leave because we're under 500 employees. So what are our options here? Do we have to comply with this? The answer is yes for now. However, there are some language that's in the Department of Labor FAQs stating that if you're an employer that's less than 50 employees, that there might be a possibility to kind of plea your case and state that by offering this to employees, this expanded family medical leave or even the emergency paid leave, that by notifying, you know, whether it be the Department of Labor, the U.S. Treasury, IRS, that it would affect your viability to sustain operations and it's going to severely impact your business, then there might be an exemption under that. We're just unclear what that may look like, what the process is for that, so stay tuned. So we've talked about just a broad overview of the expanded or emergency paid leave and family medical leave expansion. What we haven't talked about is the poster. So many of you have already received this, I'm sure. This is direct from the Department of Labor, and this is what it looks like here. And it certainly provides a much narrow language, very concise, and it really gives a pretty good description of what an employer with less than 500 employees, whether they're public or private, what they may be obligated to extend to their workers who are unable to work remotely or through telework and be affected by the COVID-19 in certain ways. Now, what I'd like for you to do is pay attention to this. This is real important. There is a QR code down at the bottom of this notice. Again, this can be found on the Department of Labor website, or you can certainly contact our office and we'd be more than happy to get this sent over to you, that it must be posted by April 1st and would carry on through December 31st of this year. In relation to that code that I mentioned earlier, if you take your mobile device and you scan it, it will bring up the whole like FAQs from the Department of Labor, a lot of really good information point by point. And this all took effect on the 25th of this month of March. And so it is up to date as far as we can tell at this point. There's no other updates to where we stand. So be sure and do that. Be sure and post it. If you do currently have employees who are telework or working remotely, you can certainly get this over to them and obligated to do so by email. You can post it on your intranet, through an employee portal, what have you. And then also, if you're continuing to hire staff, you need to make sure that they have access to this poster as well, whether it be on your premises or through telework. So as we're navigating this and employees are quickly having questions about attendance and what they're subjected to, whether or not they're having daycare closure, or school closings, or they think that maybe somebody in their household may be symptomatic of COVID-19, that we're having employers starting to question their current employment policies on attendance. And the question is, employers are asking, well, should we waive any of all attendance, policies during this COVID-19 crisis? And, this is a trying time. Everyone is stressed. Therefore, it's best to adhere to current attendance policies that you have. But, use common sense and reason. When it comes time to having that conversation with an employee, maybe they are approaching you saying, I'm not feeling well and I'm not going to make it in. Don't automatically jump to that they've been diagnosed with COVID-19 or it's even related. Maybe they just woke up and they have a headache or a stomach bug or just not feeling well. And so we want to make sure that we are communicating with that employee and we're assessing the reason for their absence. And if it is COVID-19 related, that we're navigating through that. After April 1st, we're going to be determining, one, can they telework? Can they work from home? Is this something that's being extended to another person in that similar position or capacity that may have COVID-19 symptoms, related absences, and would they qualify under the emergency paid leave or, better yet, the expanded family medical leave? So we don't want to jump to conclusions just yet. So it is important to follow your current policies. And of course, we're navigating with the new times of this COVID-19, making sure that we're applying the new legislation. All right, so as we're talking about attendance concerns, any kind of policies that you're following, conversations that you're having with employees, be sure and document. Don't stray from that. That should be normal protocol anyway, that there's some sort of documentation that's taking place when someone calls in ill or absent, away from work. We want to find out what the purpose is, and it's not necessarily to get into their personal business per se or their health-related business, but we do need to determine the reason for their absence just like we would any other time. Okay, so as we're talking about attendance and ADA and what's protected, what's not, having a lot of correspondence or emails and inquiries from clients on that. And we do find, or have watched our share of webinars and educating ourselves as well, and that COVID-19 is simply considered a virus. It's just that it's typically transitional, it's minor according to ADA. However, should an employee develop some type of complication that keeps them in a state of a temporary disability like pneumonia or any other type of respiratory complication, and they're going to be out and it's a little bit longer than one anticipated, it could very well be considered under ADA. Now, we won't dive too much into that today, but certainly if something like that should occur and you need some further assistance, by all means, feel free to reach out to Human Resource Advantage. We have our share of consultants on hand fielding these types of questions daily, or to seek your legal counsel or your HR department as well, as there may be something that is considered a disability, whether it's under the expanded ADA or it may be something that's within a mini ADA law within your state. So on best practices, should an employer become aware that an employee has been diagnosed with COVID-19, what are the rights as far as employing or informing other employees? And lots of information on this. There's also people asking, is this a HIPAA violation? Is this a privacy violation? And right now, we are being told that it is best practice that if you are informed by an employee that they've been diagnosed truly with COVID-19 and they're needing to stay home for it, that simply you inform other workers within that particular division that there has been some exposure. You don't necessarily need to identify the particular employee or the individual, but rather we are going to take precaution and disinfecting the area and using all of those recommended measures by the CDC in order to prevent additional exposure. We don't know if it happened at work. That's just the thing. It could have been the individual that did report out for the COVID-19 diagnosis. They could have, obtained it anywhere, not necessarily the workplace, but an employer does have an obligation to notify their coworkers that there has been a potential exposure and that we need to take all measures necessary to disinfect the area and make sure that others don't contract this as well. Okay, so on documentation, very, very important. We're having employers ask about, well, what am I supposed to document during this time? And we say it's probably no different than if you had another FMLA leave, other than you may not be using that particular form. But if you do have an employee for a COVID-19 reason and they qualify for the emergency paid sick leave or the expanded family medical leave, be sure obviously to obtain the employee's name, the qualifying reason for their leave, any kind of statement that the employee is providing on their COVID-19 related case, and then also the dates in which the employee is requesting. We don't have to necessarily extend that blanket, through the remainder of the year, as it may be short term. It may be where the employee's school, everything has kind of ceased a little bit and we get back into normal operations and the full 12 weeks may not be needed. So be sure and document that as well. Also, you'll be wanting to keep this documentation should the employer want to claim for a tax credit, for reimbursement. So you want to make sure that we have all the necessary documentation and tracking. The IRS will be providing some applicable forms forthcoming, is what we understand, on those information and procedures in order to obtain any and all necessary tax credits for this purpose. So finally, in wrapping this up, what we feel at Summit Safety, Human Resource Advantage, we are here for you during this time. We all have families that we're trying to protect. We all have employees that we're trying to protect and, want to sustain our business and normalcy the best we can. And so we're always, talking to employers and we're stating that communication is key here. The more you communicate with employees about the status of their work, about the status if they have any issues or concerns, that open door policy and truly exercising it is really, really going to be critical during this time. and making sure that employees feel comfortable with visiting with leadership or their supervisor, their human resource department, or even your contracted HR provider such as Human Resource Advantage, or even your safety consultants at Summit Safety on certain workplace issues or concerns. Those are going to be really key there. We'd certainly like to thank you for taking the time. We know it's very, very busy. You're trying to establish a new normalcy, and most importantly, to sustain the well-being of your workers, your employees, your family, and your business as well. If we can help in any way, all of our team here at HR Advantage is here to help you, as well as Summit Safety. Thank you and have a great day.